Welcome, everybody. Hello to another edition of the Florida Appellate Review Case Law Update. I am joined by two fellow Palm Beach County Justice Board members, Jennifer Dinetz and Jeff Adelman. Let me just briefly introduce both of them. Jennifer is an attorney at Clark Fountain, La Vista, Prather, and Lickey Rubin. That's a handful, but five extraordinary attorneys that Jen works with. Now, Jen specializes in personal injury, products liability, catastrophic injury cases, wrongful death cases. In addition to being a board member for the PBCJA, she is also the treasurer of Fall in Palm Beach County. She's the co-committee chair with the Palm Beach County Bar, the personal injury section, and just a wonderful, wonderful attorney in person, a mother of two dogs, Billy and Palmer, and just recently married. So thank you, Jen, for joining us.
Thank you.
Jeff Adelman just recently joined the law firm of Brotman, Nussbaum, Ibrahim, and Adelman. He is a Florida Supreme Court Circuit civil mediator, board certified in civil trial, the immediate past president of Fort Lauderdale, Aboda, and in the future, I think we'll be hearing some more with Jeff's involvement statewide in Aboda, so stay tuned for that. So thank you, Jeff, for joining me as well. Now, today's episode, we're going to discuss misconduct. We've got a selection of 4 cases where there was misconduct by the attorneys themselves within each of the cases, or alleged misconduct. What's interesting is that in 3 of the 4 cases, the appellate court did not grant the relief requested by the appellants in terms of new trials or sanctions. And in only 1 of the 4, ironically, the one where there were no objections raised at trial, was the one where the appellant was granted a new trial. So we're going to start with 2 cases that Jeff's going to talk about, issued last week, June 18th, on the same day by the same panel of the 5th District Court of Appeal, involving the same 2 attorneys on both sides. So take it away, Jeff.
Well, the first one I'm going to talk about is the Bowers versus Tillman et al. Case, decided June 18th, so just last week. And it involves Dale Goebel, defense attorney, and plaintiff's attorney Jeff Bird, who clearly did not like each other throughout their cases, and I'm sure that these are not the only 2. But what struck me about reading this is just some of the egregious conduct in violation of a motion in limine. Mr. Goebel's expert witness referenced medical records that were clearly banned by a motion in limine, but let it go forward anyway. And in addition to that, there's a pattern here with Mr. Goebel, who, again, we're going to get into it, that there's a order that he has been up for sanctions over 30 times, and there's a continuing pattern here. And looking at specifically in this case, the records that Dr. Kowalski, the expert witness, referenced were to show some chiropractic treatments that, again, were banned from this trial, and he brought it up anyway. The judge dealt with that at the time, but things were so bad that the judge wrote that jurors were snickering to themselves about how badly the attorneys were treating each other. You don't usually see something like that. And, it got to a point where Mr. Goebel is a repeat offender. And in this particular case, he even put up a slide saying, lawyer referred to chiropractor in the closing argument. And when they had a sidebar, did not take the slide down, even though that also was not allowed. So what happened in this case? Well, the judge, the panel criticized. They brought up Mr. Goebel's record. They said he's a repeat offender. But at the end of the day, they did not give the relief to the appellant of reversing the case. They said that, basically that they were not going to, it wasn't rising to the level requiring reversal, even though at one point there was a issue over a redaction, something that should have been redacted that wasn't, that Mr. Goebel did not bring up to the court, that clearly was a clerical error. There was just a lot of shenanigans in this case. And I'm glad you asked me to go first, because my next case, Andrew, involves the same attorneys. And it's so similar that Judge Cohen, who wrote the concurring opinion, basically cut and pasted his opinion in the Bowers case to the Simone case, which was also decided on June 18th. And in that case, again, there's bad behavior going on, misstatements, things that were not going to be supported in the evidence being brought up in opening arguments. And what it really comes down to is the attorneys are going to do what the judges permit. And if there's not going to be any admonishment or that has teeth in a trial, the behavior continues. I mean, Mr. Goebel has over 30 sanction matters right now. Why is that? I think that the reason is that while we all know that this behavior is not appropriate, very few judges are taking the extra step of saying, you know what? I've had enough mistrial. You're going to pay the costs. That hasn't happened enough with some of these bad actors. You know, it's really incredible to read both of these back to back and not have any sanction on Mr. Goebel for this. And while they do mention Mr. Byrd, the plaintiff's attorney, has also been admonished before. You know, it's sort of like sport, you know, a hockey referee, he doesn't see the first thing. Well, here you see everything in front of you. You can't just say both sides are equally guilty of all the infractions. There is just a laundry list of attempting to get mistrials in cases by Mr. Goebel. And the judge actually said Mr. Goebel has occasioned more mistrials in these two cases alone than most lawyers will have in an entire career. Now,
oh my God.
Yeah, it's insane. So what do we do? I mean, here you have these judges, these appellate judges who don't like the conduct, but aren't willing to let it go to the next level. How else are we supposed to act professionally with civility and all that if the referee is not going to make the call? Like, again, like in hockey, not putting the whistle away in the third period. You can't do that in a trial. And I feel like a lot of times that's what happens in my experience. And seeing this here, I'm not alone. But Andrew, I'd like to get your thoughts on these two cases together, because you don't usually see a concurring opinion where they just copy and paste it because the behavior is so similar.
So certainly both of the decisions from the appellate perspective mirror the standard of review. You know, the appellate judges are not fact finders. They are not in the same position as the trial judge. And so with an abuse of discretion standard of review, it certainly is understandable why the appellate courts in both those decisions affirmed. I think you can safely assume that had the trial court granted a new trial to the plaintiff and granted sanctions in the second case, I think it's safe to assume the appellate court would have affirmed both of those things as well. And so that returns us back to your theme of the trial judges to, you know, they are independent referees, but when one side, and it can be on either side of one of our cases today involves plaintiff's counsel who was accused of misconduct, or two of our other two cases or whatever. And so you mentioned last week, it's a little ironic, the timing, but on the same day that the 5th District issued both of their decisions, Mr. Goebel, in a circuit court case in Brevard County, and we'll have this up on my firm's website and on the PBCJA podcast here, a case called Rodriguez versus Rhodes, the name you don't have to write down, but in that case, the trial judge granted a mistrial. The first trial ended in a mistrial because of Mr. Goebel's conduct. In the trial court, the plaintiff then filed a motion to strike the defendant, the tortfeasor's pleadings. And the order noted that the tortfeasor had no role in Mr. Goebel's misconduct at trial, but the trial court struck the defendant's pleadings in that case. And the plaintiff asked for all fees and costs from that mistrial. And although the trial court's order doesn't specify that the fees and costs are going to be granted, the order notes plaintiff's motion is granted. And so my read on that is that Mr. Goebel and Mr. Goebel's law firm are going to be hit with a substantial fees and cost judgment there from causing the mistrial. And so there's an example where a trial judge in the first instance, has that authority. The plaintiff's counsel asked for the ultimate sanction in having the pleading stricken, but there will now be a trial on damages only in that case.
Well, just getting back to the Simone case, this was the second trial, and the attorney was trying to get sanctions for causing a mistrial, which apparently there is a pattern here with this defense attorney of attempting to purposely trying to get mistrials. So what you just mentioned has happened. Jen, what are your thoughts when you hear about this case?
It's interesting because as you're reading it, I'm like laughing in an embarrassment way because I'm embarrassed for them. But then you're right, the sentiment that it is the ref's job, it's the judge's job, the trial judge's job to keep order in the court. And I think a lot of us will say that there are different levels of judges and different things that we like and dislike about judges. But one thing that's consistent is a judge that retains order in their court, just makes decisions, makes educated decisions, but rules. And for an opinion to even say the jurors were snickering, I mean, that's not stuff you usually read in opinions. That's more dicta, if anything, but that's part of the opinion, and still nothing was done. It's funny in an embarrassing way, and then you think this is not right. Something does have to be changed, and it's refreshing to hear, Andrew, that some judges are doing what they're supposed to do and laying down the hammer.
Right.
Judge Cohen says in his concurring opinion, in my view, the instant cases establish a continuing pattern of conduct by Mr. Goebel designed to provoke the granting of mistrials. So, I mean, it's no secret what's going on here, but the trial courts, I mean, if they want civility and they want ethical trials, they got to enforce it. Otherwise, it just encourages this kind of behavior.
It was just one last thing. It was interesting. The order last week, and I know it's only a trial court order, but when the trial judge went through the factors on whether to strike the defendant's pleadings, noted the backlog of cases here in the COVID era, and that how the administration of justice had been so frustrated because for the plaintiff in that case to now go and get a retrial, it may be a year until the plaintiff gets a new trial date. And so I think for all of us as we go forward with the administrative backup, which is through nobody's fault, we just had a once in a lifetime pandemic, but I think it's even more important that we have civility and professionalism, but that when there is misconduct, you want to be the innocent. You don't want to engage in a tit for tat. You've got to be the better person and ask for the sanctions and for our trial judges to impose those sanctions when they're warranted.
Yeah,
go ahead, Jeff.
I mean, just hiding records in other records. This is the type of conduct we're talking about here. And, if a judge sees that, and again, I personally had this happen to me. If a judge sees that, I mean, it's obvious what needs to be done, but to say, you don't want to do it, you don't want to rock the apple cart. I mean, that's kind of what your job is, if something's wrong.
We're going to segue now into Jennifer. I know you have a case from the 3rd District. It is what I will say just as a premise. It was the courts in civil cases have said the courthouse doors are almost completely closed for fundamental error, which is a standard that a party has to prove on appellate review when there's been no contemporaneous objection below, when an issue has not been preserved. And this was a case where the moving party, the defendant, had to establish fundamental error on appeal in order to receive a new trial. So take it away, Jen, on the case that you're here to discuss.
So out of the 3rd District, there's, just for the record here too, there's no motion for rehearing. There's nothing else coming from this case. So we don't have that citation for you all yet, but it is a final decision. So this was out of the 3rd. It's Florida Peninsula Insurance Company versus Rafael Nolasco. So in this case, it was a more simple, if you will, 4-day trial where the plaintiffs brought suit against their insurance company for repairs that needed to be done for their home. It went to trial. In the trial, I wouldn't say that they were as egregious as in the previous case, but the plaintiff's attorney in their closing argument was calling the other side's expert a liar, or just say this was not 100% the truth. Maybe it was 90% the truth, but they're lying to you. They're hiding things from you, and over and over and over. And then when they were talking about the actual plaintiff, or the client there, it was a woman named Miss Jackson, and they just kept saying Miss Jackson and her drama. The amount of times they said her drama, it's as if that was the theme of their case. So they kept saying, you know, she complained about this and her drama, and over and over. And then went back to kind of attacking the certain witnesses, again, calling them a liar, to the extent that the trial court stepped in upon no objection lodged and said, counsel, you got to move on. We're not talking about this. Be respectful, essentially. The takeaway from this is that counsel sat the entire time and did not lodge one objection to any of this egregious behavior. And then on appeal, they brought up all these issues that they shouldn't have said in closing argument. Now, there is a test that has been come out within Florida. It's the Murphy case, where it's a multiple step test to establish when there's non-objected to issues in closing argument, how do you establish that there's fundamental error? And typically, as Andrew said, it is a very, very difficult test to overcome, because the whole purpose of objecting during trial, whether it's sustained or overruled, is to preserve the record. So the appellate court can say, hey, there's an issue here, and they can address it. But how are they going to address it if there's no preservation of it? But in this case, despite there being no objections, the appellate court found that the closing arguments did attempt to impugn the integrity of a witness by calling him a liar, and doing that falls squarely within the category of fundamental error. So there was no need to preserve the record, because it was so egregious that they found that there was fundamental error. One thing that I did want to note that we were discussing previously is there was a statement within this that when an attorney, an advocate and an officer of the court, they come in and they assume that role while they're in trial, when they start giving their personal opinions, i.e. this person's a liar and the evidence is not necessarily showing that, but it's just your personal opinion, you are stripping yourself of that officer of the court title, and you're now becoming a lay witness. And a lay witness is now subject to cross-examination, which was just so concisely and perfectly said that would make me err on the side of always being cautious. And even if the evidence does show, hey, this person was lying, I'm not going anywhere near that. So let's talk about that, where there's no objection, no preservation of the evidence, but here we are with a remanded trial, and now a new trial was granted. Andrew, what are your thoughts on that?
Right, and as I said, I mean, had I predicted the outcome here, I would have predicted an affirmance, not because the conduct wasn't outrageous, but just because the fundamental error standard is so hard to reach. And it's incumbent upon all of us to timely object, to raise a specific objection. And if the objection is sustained, we have to immediately ask for a mistrial, or at the very least at the end of closing argument. And here, as you noted, defense counsel didn't say anything. And it's always easy to Monday morning quarterback after the fact. Why didn't you object? We all think, well, when you're in the heat of the moment, obviously, sometimes you don't want to stand up, and the jury thinks you're trying to hide something. And so this is one of those rare instances, though, where the panel here found fundamental error. As you noted, there was no motion for rehearing filed by the plaintiff in the case. And so there's now going to be a retrial. What's interesting there, one thing that you mentioned the repeated reference to the phrase drama. Now, I think some of our audience or some people reading the opinion may say, well, how is using the phrase drama necessarily a sexist term, right? Mm-hmm. Well, what's interesting here is that the trial judge believed that it was sexist, and the appellate court noted that the trial court was in the best position to have made that statement. And so the trial judge, the appellate judges are not in the courtroom. There's not a video transcript. The trial judge was there and heard that term repeatedly referenced. And so this is another instance where the appellate court deferred to the trial court on that factual finding. Now, the appellate court reversed the trial judge's denial of a motion for new trial, but that's just an instance. We all have to be careful in the language we use. We can't get in the mind of the plaintiff's trial counsel there and know whether the plaintiff's counsel was sexist, but what was important is that the words which were used gave a reasonable impression that they were sexist. And so I think that was a notable thing that we all need to be cautious about, moving forward. I don't do closing arguments. I know both of you do them, and some people prepare their closing arguments and write them out. And then when you get in the heat of the moment, it's sometimes, you may not always follow the script or whatever, but I think it is a good thing, for closing, have somebody else in your offices or outside, practice it, read it, because sometimes how you think it sounds may not come across that way to, to the listener or to the audience. And so that would be my
something to
advice.
add just to that, because I thought the same thing reading it. It's like, well, her drama, how is that sexist? And I was trying to understand that. And another phrase that they used that the trial judge did not appreciate was when they were speaking about the expert, they called them a hired gun, which at first when I read that, I'm like, hey, that's pretty clever. But then when you put all of everything together, it paints a horrible picture. So I think that when you put everything next to each other, it's the totality of the circumstances, if you will, the trial judge made the right decision.
Yeah, for all
hired.
our audience. Oh, go ahead, Jeff.
I was going to say the hired gun thing screamed out to me because I've always been told never, ever, ever, ever say hired gun.
Right.
So the fact that I actually see it here, I'm like, oh, wow. I mean, aside from everything else, I mean, obviously the reference to the drama and everything else. I mean, I think that I would be suspicious. I don't think he's probably said that to a man who's been opposing him. That's kind of there's definitely some sexism there, and obviously the judge fell there. But the hired gun language, I mean, I think pretty much everybody's always told me never say that.
It's very strong.
Yeah.
You could say this hired by the defense, but
right.
I wouldn't.
And they're always hired by the defense, but you can't say hired gun.
Yeah. Very strong.
Right, there's all sorts of ways on both sides for retained experts and plaintiffs treating physicians, when defendants are exploring the financial relationship between plaintiff's counsel and treating physicians. There's all sorts of ways for proper impeachment. There's a case in front of the Florida Supreme Court right now addressing the discovery. But yeah, the phrase hired gun should be out of all of our vocabularies throughout a trial from start to finish. Our final case, and are there any more thoughts on that case? I didn't mean to cut you off, Jen, or anything
No, let's
else?
go to the last one.
Okay, so the final case, it's RJ Reynolds Tobacco versus Kaplan. It's an Engel progeny case, and closing argument cases, Engel cases, there are dozens of them now over the years. Engel cases, most of them go to trial, and they are heated, they are lengthy, and the tobacco companies did some pretty reprehensible things over decades. And so they often get heated on both sides. Now, the citation for this, it's 2020 Westlaw 7239575. It's a December 9, 2020 opinion, but it's still pending on a motion for rehearing and motion for rehearing en banc. Now, the plaintiff in this case recovered $5 million, $2 million in compensatory damages and $3 million in punitive damages. Now, the plaintiff's counsel in the case, there were a couple of references which the majority and concurring opinion both found, all three judges found were rather egregious. There was a reference with the appellate court felt that the plaintiff's trial's comments discussing Schindler's List was analogizing the conduct of the tobacco companies to the Nazis. And there was also a long discussion regarding George Orwell in 1984. Now, in that case, unlike the case that Jen talked about, defense counsel did contemporaneously object, and the objections were overruled. And so on appeal, the defendant did not have to reach a fundamental error analysis, which was met in Jen's case. But as we've said, it's almost impossible to meet. Instead, the defendant there had to establish that the comments were so prejudicial and inflammatory to require a new trial. Now, the appellate court affirmed. And so that was obviously good news for the plaintiff in that case. But it was clear that the panel did so very, very, very reluctantly. The concurring opinion in particular was very harsh. The majority noted that it was the fifth time that the plaintiff's trial counsel had an Engel case where closing argument had been addressed in a published opinion. 3 of the prior 4 times had resulted in new trials for the defendant. And in the fourth case, the only reason the appellate court hadn't granted a new trial there was because the objections, because they were not preserved. The objections were not preserved for appeal in that fourth case. And so, like Jeff's first 2 cases, the theme to take from this case is that the appellate court was really putting the onus on trial judges to take control. The trial court here didn't do anything wrong. The trial court, in good faith, denied the defendant's motion for new trial. But if you read this carefully, it's a lengthy opinion. The appellate court was really saying the trial court is where the referees need to really referee. And when there are egregious comments, or what the appellate court characterized, and I think reasonable minds could characterize it as egregious. I know some people would disagree or whatever, but where trial judges see those kinds of egregious comments, the only fair remedy would be for a new trial for the non-moving party. Now, I want to just briefly discuss the concurring opinion real briefly, and a portion of the appellate, the beginning of the appellate opinion. I'm just going to read the paragraph from Judge Klingensmith. I reluctantly concur in the majority opinion, but write to address a shortcoming in our jurisprudence as highlighted by this case. During oral argument, appellee's counsel, which is plaintiff's counsel, implored this court not to punish their client for trial counsel's improper argument by reversing the jury verdict. In follow-up, we asked appellate counsel how we should deal with issues of repeated attorney misconduct other than by reversing cases where the boundaries of permissible arguments set forth by this and other courts have been flouted. The response we received essentially from plaintiff's appellate counsel, and quote, I don't know. I mean, that was the appellate court's quote. Succinctly put, neither do we. And so the appellate court here, as I said, very reluctantly affirmed. Now, why did the appellate court affirm in spite of what they characterize as this repeated egregious argument by what they characterize as a repeat offender? It had to do with the facts of the case. As I mentioned, the jury awarded $2 million in compensatory damages. Plaintiff's counsel had asked for $8 million. And so, and the jury, although the jury awarded $3 million in punitive damages, that was far less than requested by the plaintiff's counsel in closing there. And so the appellate court here looked at the outcome, the length of the trial, the reprehensibility of the tobacco company's conduct in evidence, and held that the error, the trial court's error, or the trial court's failure to sustain the objections had not caused harm to the defendant. Now, as I noted, the defendant has a pending motion for rehearing, has a pending motion for rehearing en banc in front of the entire court. We don't know what the outcome obviously is going to be. I'm not in the prediction business. I know neither are you. That's why the appellate courts make these decisions. But I think it's safe to say here that even if the appellate court affirms and doesn't grant rehearing, that this case is going to be appealed to the Florida Supreme Court. And so it is an example. The plaintiff here may have won the battle so far, but may not win the war ultimately. And besides that fact, there's an appellate decision here with the message to the trial judges and to the trial bar that in the future, the result may be different. And so it's another takeaway like what Jeff talked about from the 5th District last week, where the appellate courts are saying, our hands may be tied here, but we implore trial judges to take control in the trial court level, and where misconduct happens, where egregious misconduct happens, to take the only appropriate recourse, even if it's unfair to the litigant, which is what Judge Klingensmith mentioned, and he goes into depth in his concurring opinion here regarding that the only remedy is going to be to do what? To grant new trials, to impose attorney's fees and cost sanctions on a party who's on a counsel who's responsible for a mistrial or for a new trial. So that's my takeaway from this case. Any thoughts from either of you?
Well, I love the quote, and well, there's so many good ones from Judge Klingensmith here, but the one at the very end.
Yes.
There's an old saying that there is no education in the second kick of a mule. Our opinion in this case provides the 5th and hopefully final kick needed to emphatically deliver the majority's message to this trial counsel specifically, and to trial judges more generally. We've made our expectations clear, and our tolerance should not be expected in the future. Wow.
Love it.
Right, and it's the same message we saw last week from the 5th District, the concurring opinion there, where the appellate judges here, they have this deferential standard of review, which they're required to follow. Although the concurring opinion in the Kaplan decision did say that perhaps we need to revisit the standard which we have established in deciding whether to grant new trials for improper closing argument, but bound by precedent and bound by the standard of review, the appellate court in all three of these cases, Jeff, both of your cases, and in the Kaplan case from the 4th District, affirmed in spite of what all three panels saw as egregious misconduct. And so I wouldn't take away from this from trial attorneys out there to repeat this conduct that we see, to repeat the comments, the statements that we see in these closing arguments. Quite the opposite, I think, should be the message for all of us, to not do this, and to be above board. And the more above board we are, the more likely we are when we see misconduct from our opponents to have the credibility to go forward and ask for sanctions. Because there are, in the course of a case, it's not just striking pleadings, it's not just moving for attorney's fees. There are going to be times where you move for sanctions for some small issue of a case. And if you have yourself been sanctioned, or if you yourself have been, it's going to be a lot harder for you to get that credibility with trial judges in your own cases, your firm's own cases. And besides, it's just not the right thing to do, to denigrate ourselves, and the practice as a whole by engaging in misconduct. So that's my takeaway from the case. As we wrap up here, any closing thoughts from either of you on our series of cases discussed today?
I would just say, clearly they affirmed, but they affirmed kicking and screaming. So take that for what it's worth. They did not want to.
Right, exactly.
I think that in particular, reading that last concurring opinion on the Reynolds case, there is some hope that the judges, the appellate judges, are going to tell the trial court judges, look, you need to do something. You can't just let everything go, because there's too many of these instances happening. It's usually the same lawyers, and you have the power to stop it at your level before it gets to us. And I hope that we see more of that as our state courts are becoming more federalized. We're having to disclose more early on. Maybe we'll see some improvement in that regard, but I really think at the trial court level, the message is being delivered by the appellate court. You have the power to do something now, and let's hope that it starts happening a little more. Because again, it seems like it's the same people again and again.
There definitely, the opinions this week were repeat people in the appellate courts, and I think trial judges as well, not these particular lawyers, but in general, I think we all in our practices, right? We see some of the same firms, the same people who we think are engaging in misconduct, and on both sides, plaintiff sides or defendant side. These decisions are not pro-plaintiff or pro-defendant decisions, nor should they be perceived as much. It hurts the entire practice of law whenever any of this, it reflects poorly on all of us, right? We are all guilt by association when these types of things happen, and it's unfortunate. I want to thank you both, Jen Dinetz and Jeff Adelman, for joining me today on your case law update, and we look forward to doing this soon in the future. Thank you all for joining us and listening. Welcome back, everybody, to the Florida Appellate Review case law update. Now, for those of you watching on video, you'll notice that my wardrobe has changed. The reason for that is the case which I addressed in the podcast, R.J. Reynolds and Philip Morris versus Kaplan, it was pending on rehearing at the time of our podcast, which you heard me discuss before. Well, before we published the podcast here, the 4th District issued its opinion on rehearing. And so I want to just briefly summarize for everybody the opinion on rehearing. Now, in this case, the defendants had moved for rehearing and rehearing en banc. The appellate court denied the motion for rehearing en banc, which was the request for the entire court to hear the matter. The appellate court, the panel technically granted the motion for rehearing, but that was only to issue a revised written opinion going to more depth explaining why they were reluctantly affirming. Now, again, on rehearing, the appellate court categorized the two areas of closing argument as egregiously improper, stated that the plaintiff had crossed the line with both of these matters, and that the closing argument had been targeted solely to inflame the jury. And the appellate court, both the majority and concurring opinions, I think sent very strong messages to the trial bar not to engage in this egregious misconduct. And I think as well, the appellate court sent a message to trial judges to be vigilant in monitoring and imposing the harshest of sanctions when there is egregious misconduct. Now, what was different on the opinion on rehearing? Well, the appellate court explained in more depth why it was reluctantly affirming why there was no reversible error. So the appellate court noted that the improper areas of closing argument, although egregious, had been brief and isolated. The appellate court also stated that these areas of closing argument had been somewhat incoherent. And in fact, the appellate court stated that much of plaintiff's closing argument was somewhat incoherent. So essentially a no harm, no foul. And the third reason for there being no reversible error is that the appellate court on rehearing noted, as it had in the initial panel decision, that the jury awarded far less than the plaintiff had requested, both as to compensatory damages and as to punitive damages. The other difference on rehearing, on the opinion on rehearing, is that the appellate court explained and addressed the harmless error test. Now, the harmless error test in civil cases, it arises from a case I won in the Florida Supreme Court in 2014, Special versus West Boca. Now, under the harmless error test in civil cases, the party which introduces error into a case as the beneficiary of the error has to establish on appeal that there was no reasonable possibility that the error contributed to the verdict. It's a hard test to meet for a party which has introduced the error. Now, the appellate court here held that the harmless error test was inapplicable, and so therefore the plaintiff did not have the burden to establish that their egregious improper closing didn't contribute to the verdict. The appellate court explained that the trial court had correctly denied the defendant's motion for new trial, and so since there was no error, the harmless error test was inapplicable. I think it's pretty clear that the defendants in this case are going to be seeking Supreme Court review on that issue, on the harmless error analysis test, and whether it applied under the facts of this case. So that is just a brief summary of the decision on rehearing. Just in closing, I want to thank everybody who has subscribed to my podcast at Florida Appellate Review, and also to the Palm Beach County Justice podcast with my co-hosts, Jeff Adelman and Jen Dinetz. My podcast, I'm going to have not just case law updates, but also some more personal stories with trial attorneys about their practices and their community service. I hope that there's an audience for that. And if you're interested in speaking on one of those podcasts, just please let me know. Andrew at Harris Appeals, or you can call me at my office number 561-867-9500. And looking forward to next week's case law update with you all. Thank you so much. Bye-bye.